Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law, where we bring you the latest developments from all courts across India. Let us start. A 7-judge constitution bench of the Supreme Court is considering the question whether members of the parliament or state legislatures are immune from prosecution in bribery cases revolving around any speech or vote in the House because of the parliamentary privilege conferred by Articles 105 Clause 2 and 194 Clause 2 of the Constitution. The bench today began hearing the reference of 1998 P.V. Narasimha Rao judgment, which was referred last month to a larger bench. The 7-judge bench comprising CJI D.Y. Chandrachud and Justices A.S. Bopanna, M.M. Sundaresh, P.S. Narasimha, J.B. Pardewala, Sanjay Kumar and Manoj Mishra. The main case here relates to Sita Soren, a member of Jharkhand Mukti Morcha, who was accused of accepting bribe for voting in favor of a particular candidate in the 2012 Rajya Sabha elections. Subsequently, a charge sheet was filed by CBI. Challenging the same, Soren filed a petition before the Jharkhand High Court on the ground that she enjoyed immunity under the Constitution. But the High Court dismissed the petition. While her appeal was being heard before the Supreme Court, reliance was placed on the judgment in P.V. Narasimha Rao. For your information, in P.V. Narasimha Rao, a 5-judge bench of the Apex Court held that legislatures enjoy immunity from prosecution in cases of bribery in relation to parliamentary vote and speech. However, it had added that the immunity would only be extended if the legislatures carried out the act that they had taken the bribe for. In other words, if a legislature took a bribe to vote for a particular candidate but later decided not to go ahead with the same and voted for someone else, the immunity would not be extended to them. Last month, the court had said that the correctness of the view of majority in Narasimha Rao had to be considered by a larger bench. Well, today was the first day of the hearing of the 7-judge constitution bench, and senior advocate Raju Ramchandran started with the arguments. He said, one of the pillars of constitutionalism has historically been a regime of immunities and privileges. The fact that offense of bribery in criminal law is complete when bribe is given and is not dependent on performance of promised favor was of no consequence to constitutional immunity under Articles 105 and 194. He also refuted the argument that voting for Rajya Sabha elections is not entitled to this immunity because it is not a legislative vote, by saying that it does not have to be a legislative proceeding in the sense of voting in a house of legislature. This voting, though not on floor but lobby, is nevertheless a vote in legislature, and so if there is a protection for vote on a bill in the house, it should also attach to the Rajya Sabha election vote. He concluded by saying that the P.V. Narasimha judgment was a moral one and that the court should not interfere with such a carefully considered and well-reasoned judgment. Senior advocates P.S. Patwalia and Gopal Shankar Narayan also argued in favor for reconsideration of the P.V. Narasimha Rao judgment. The hearing will continue tomorrow. To read the arguments in detail, you can visit livelaw.in. And now coming to an important judgment from the Supreme Court. The Supreme Court has ruled that a person cannot be arrested by the Enforcement Directorate for merely not cooperating in response to the summons issued under Section 50 of the Prevention of Money Laundering Act. These observations were made by the Supreme Court while declaring the arrests of directors of Gurugram-based realty group M3M, Pankaj Bansal and Basant Bansal in a money laundering case as illegal. A bench comprising Justices A.S. Bopanna and Sanjay Kumar said that failure of the accused to respond to the questions put by ED would not be sufficient for the investigating officer to opine that they were liable to be arrested. Because, as per the mandate of Section 19, someone can be arrested only if the officer has reasons to believe that the person is guilty of offences under the PMLA. In this case, ED said that the responses given by the accused were evasive in nature. But the court refused to accept this reason and said that in any event, it is not open to ED to expect an admission of guilt from the person summoned for interrogation and assert that anything short of such admission would be an evasive reply. The court also mentioned the right against self-incrimination provided by Article 20, Clause 3 of the Constitution and said that custodial interrogation is not for the purpose of confession, and that merely because an accused did not confess, it cannot be said that he was not cooperating with the investigation. Another significant observation by the court is that the ED must inform the grounds of the arrest to the accused in writing. To read this important judgment in detail, you can visit our website at livelaw.in. The Supreme Court bench comprising Justices Sanjeev Khanna and S.V.N. Bhatti today heard two petitions filed by Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia against the cases registered by CBI and ED over the alleged Delhi liquor policy scam. While CBI is probing the allegations under the Prevention of Corruption Act, ED is handling the money laundering case. Sisodia was first arrested by CBI in February and later ED arrested him in March this year. Senior advocate Abhishek Manu Singhvi addressed the bench for over 2 hours today, seeking bail for Sisodia in both the cases. He said that being a sitting MLA, Sisodia was not a flight risk, and there is no question of him influencing any witnesses. He also cited the ailments of Sisodia's wife as a reason for grant of bail. To the allegation that there was a conspiracy coordinated by Vijay Nair and other individuals along with the South Group to give extraordinary profit margin to wholesalers and that Vijay Nair was Sisodia's close associate, Singhvi replied that there is no material to prove it. The reliance was on various vague statements that he assisted in the proceeds of crime, but there was no money trail. Singhvi also told the court that all other accused in the case, the principal perpetrators against whom money trail has been found, have all been granted bail. Further, Justice Khanna questioned Additional Solicitor General S.V. Raju, who is appearing for ED and CBI, as to why the political party, which was alleged to be a beneficiary, was not made an accused in the case under the Prevention of Money Laundering Act. The ASG will be arguing tomorrow. You can read the full arguments on our website at livelaw.in. If you remember, recently Patna High Court affirmed the validity of caste-based survey in the state of Bihar, terming the Bihar government's decision to conduct the survey as perfectly valid and initiated with due competence. The survey has been completed and recently the first set of data from the survey was released. According to this data, extremely backward communities constitute 36.01% of the population, and an additional 27.12% comprises backward classes. When combined, these groups form the other backward classes, that is OBC, constituting a substantial 63.13% of the state's population. In a significant decision post this survey, the government has now announced a 10% reservation for economically weaker sections in the state's judicial services as well as in government-run law colleges and universities. The decision was formalized during a cabinet meeting chaired by the Chief Minister, and a notification with the details will soon be issued. And now an update on the Gyanvapi Mosque survey. The scientific survey of the Gyanvapi Mosque by Archaeological Survey of India had started on 4th August to determine if the mosque was constructed over a pre-existing structure of a Hindu temple or not. ASI team surveyed the inner and outer walls, the cellar and other parts of the premises except the Wazu Khana. According to the earlier order of Varanasi court, ASI had to submit its report pertaining to the survey on 6 October. But the ASI has now filed an application seeking a further 4 weeks' time to file its report. The application states that the survey is expected to take some more time as a lot of debris consisting of garbage, loose soil and building materials are dumped on floor level in cellars as well as around the structure, covering the original features of the structure, and hence it is taking time for ASI to clear the same. It further states, as the court has directed ASI to conduct a survey beneath the ground of all the cellars, it is necessary that debris dumped or accumulated there be removed without causing any damage to the standing structure. Stay tuned for further updates on this issue. Last month, a bench led by CJI Chandrachud had asked the Registrar Generals of all High Courts to state on affidavits if they were allowing virtual hearings to continue. The court had also directed to state the reason if the hybrid hearing option had been discontinued. This direction was passed while hearing a petition which complained that Punjab and Haryana High Court had stopped virtual hearings completely. Well, now the Punjab and Haryana High Court has introduced hybrid mode of hearing for 5 benches from today. In the cause list, video conference links for hybrid hearing have been provided. The note attached with the cause list also said that there will be a dedicated email ID for receiving requests of hearing cases through video conferencing in all the courts. RJD leaders Lalu Prasad Yadav, his wife Rabri Devi and his son and Deputy Chief Minister of Bihar Tejasvi Prasad Yadav were today granted bail by the Delhi High Court in the alleged Land for Jobs scam case. Various residents of Bihar were appointed as substitutes in Group D posts from 2004 to 2009 in different zones of railways located at Mumbai, Jabalpur, Kolkata, Jaipur and Hajipur. The CBI has alleged that in lieu of the appointments, the individuals themselves or their families transferred their land in the name of then Union Minister for Railways Lalu Prasad Yadav's family members and a company named AK Infosystems Private Limited, which was subsequently taken over by his family members. CBI had claimed that the appointments made in the railways were not in consonance with the standards and guidelines established by the Indian Railways for hiring. Further, CBI had filed a charge sheet in the case last October against 16 persons. In July this year, the court had issued summons to them after taking cognizance of a fresh charge sheet filed by CBI. The last update for today is regarding UAPA case against the founder and HR head of online media outlet NewsClick. A Delhi court has sent NewsClick founder Prabir Purkayasth and human resources head Amit Chakravarti to 7 days of police remand in a case filed under UAPA following allegations of the portal receiving money for pro-China propaganda. The allegations came to light after a New York Times report published on 5th August alleged that NewsClick had received funds from China to create an anti-India atmosphere. This was followed by a series of raids by the Delhi police into the residences of journalists and writers associated with it, which received wide media coverage. Let me tell you, even before New York Times report, NewsClick was facing another investigation by ED based on allegations of money laundering. This had initiated multiple raids by ED into the premises of the editors, and the case is still pending. NewsClick had earlier approached the Delhi High Court seeking a copy of the complaint registered by ED in the money laundering case, which had passed interim orders in June 2021 directing ED not to take any coercive action against the website and its editor-in-chief. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.